Welcome to Compliance 101 by Red Compass, your go-to resource for demystifying foundational legal concepts and helping you navigate the ever-changing regulatory landscape. In this set of series, we'll be discussing privacy and data protection. Now, let's take a poll. If you have ever read a privacy policy or a privacy notice before clicking on I accept, like this video. And if you have never read one, tell us in the chat why you have never read. Today, we're going to be looking at the requirements of the privacy policy and also discussing consent. So, the Nigerian Data Protection Act, released in 2023, requires all organizations who process personal data or who are data controllers to notify users, data subjects, of the purpose of processing, who the data is being shared with, the technical and organizational measures in protecting the personal data, pretty much the entire yard of a privacy notice. So speaking about consent as one of the lawful bases for processing, oftentimes you hear organizations talk about how they have gotten consent. I would like to emphasize that consent is not the only lawful basis for processing, and at most times it is not the best lawful basis for processing. But away from that, consent should always be unequivocal. It should be clear to the data subject what they are consenting to, and consent for one particular processing does not equate consent for another. That means that you cannot bundle consent. You cannot say you've obtained consent for all of your processing. That's not what the law says, or that's not what the law permits. Now, away from consent and back to privacy notices or privacy policies, as it is mostly called in Nigeria. Privacy policies are required to be a clear indication to the users, in this case data subjects, of how you're processing their personal data. Means that you're telling them how the data will be collected, what data you're collecting, the name, their BVN, their passport, and what have you. It's also telling them how long you're keeping the data for, minimum of 5 years, what the data is being used for. Okay, we want to be able to use the information for fraud detection, KYC. We want to be able to validate that your identity is exactly who you say you are, or why you are sending data to a third party. If you are sharing that with anybody, you need to let them know why you are also doing that. Additionally, your privacy notice should be conspicuous. Means that when I visit your website, I should be able to see firsthand your privacy notice. Typically, you find that people put it at the bottom of the website, but it should be such that it pops up on the website to let you know that before you have even filled in your information, before you collect the details of the user, you need to let them read the privacy notice. And oftentimes, you see people put, okay, I consent to reading the privacy notice while they have actually never read it. But that's okay, you have done your bit. So this information is actually for organizations. For your own benefit, ensure that your privacy notices are conspicuous, they are easy to understand. In the case where you have users that are not English speaking alone, consider using other dialects. It is Yoruba, Hausa, French, Igbo, Pidgin, so that the privacy notice can be duly passed to them, so that the information that you want to pass can be duly passed to them. You can also make it creative. You can turn it into a video that once they come up on your website, there's a video that pops up and tells them how the information is being collected. And they also have access to read more details in a written privacy notice at some other point. Now, to call it all up, as an organization, the law requires you by virtue of the NDPA, Section 27, to notify users of how you process their information. Away from all the AI-generated privacy notices, ensure that your privacy notice has some specific details, such as the details of your organization, the third parties, if any, the technical measures that is used to protect the information, and retention period, rights of data subjects, the ability for the users to escalate the regulatory body, that's the NDPC, Nigerian Data Protection Commission, in the case of any complaints. Now, I would also like to state that rather than simply outlining the principles of data protection in your privacy notice, ensure that the essence of the principles are reflected through your privacy notice. Take, for example, lawfulness, transparency, and fairness. You need to show the lawful basis for processing, you need to be transparent through your privacy notice, and you need to ensure that the processing of the personal data is fair. Other principles, storage limitation, data minimization, should also reflect in your privacy notice. So let's stop the redundant process of just outlining everything so that we can say that we have a privacy notice, or simply using AI-generated privacy notice. Let's ensure that the principles of data protection, are reflected in our privacy notices, emphasizing on the principle of transparency. Anything that you are doing with regards to the personal data of users, let it be clearly stated in your privacy policy. Also, ensure that if you are using AI to generate your privacy notice, you ensure that you tailor it to your specific processing. What do? Are you a fintech? Are you a BaaS provider? Are you a loan platform? Are you a buy now pay later platform? Or are you just trying to buy and sell on the internet? Ensure that the privacy notice is tailored to your processing. That's our piece for today. Thank you so much for watching Compliance 101 with Red Compass. Please don't forget to like our video, share, drop a comment, and stay tuned till our next episode. Ciao.